Jonathan, thank you very much indeed. I don't know if you'd like a glass of water to pause for breath there.
But I'm okay, thank you.
That was superb, and we have a few questions which have come through. And in fact, picking up on that last point about the possibility of a de minimis being introduced into POCA, someone was asked, is that really workable? At the moment, I think there's a £250 threshold built in. Once you've got an initial consent, then you don't necessarily have to go back to law enforcement if payments are below 250, but you can raise that threshold with law enforcement permission.
Well,
do you think there's any...
There are a number of aspects. First of all, I think if you look carefully at the £250 limit, I think it's very much a banker's limit rather than across the board. So in law, it's quite tight. Now, in practice, you'll find that actually the Serious Organised Crime Agency are prepared to talk to you. So, I mean, if you posit a scenario where you've got a company that's an empire built on crime, let's just posit the East European scenario where there's a concern that all the contracts have been obtained through corrupt practice. What do you do? I mean, every time the office secretary goes to buy a box of Kleenex, strictly you should make a report. If you discuss that sort of thing with a serious organised crime agency, they will come back to you. In fact, what they tend to do is they'll pass it off to whichever is the law enforcement agency that's investigating the matter, and they'll ask you to speak to them. And a common sense position is arrived at. I've certainly done cases where the enforcement agency has said, well, just tell us if there's a movement of more than £1 million. It's a very big case. So, you know, it all depends. The last thing the police want is to be swamped with a load of rubbish, frankly. So, I mean, there is, you know, you have to apply common sense. Well, if that's going on, and it is to some extent, why can't it apply? Why couldn't it be written into the legislation? I think it could.
Well, that's interesting, because I know that I understand the British Bankers Association is still very concerned about this whole issue of fungibility, that £1 taints everything,
Yes.
and they should be obtaining consent on everything. But there was a consultation earlier in the year, I think, wasn't there, on that, and the Home Office seemed to duck it completely,
Yes.
and nothing has been done.
Yes.
So I think there are a lot of bank MLROs, certainly in financial institutions generally, who are worried that they're breaking the law every day.
Yes, I think that's absolutely right. I mean, you may remember I've actually written a piece for your Money Laundering Bulletin on this. I'm a little more bullish, actually. I don't think the banks are in quite as much danger as they think on the fungibility issue.
But they do think it.
I know they do. I know they do.
Yeah.
Yeah, no, that's absolutely right. And I don't see for one moment why they should be put in that position. I mean, one way or the other, it should be clarified. And certainly if you had a sensible minimum threshold, then that would be one way of dealing with it.
But setting what is the right level. But as you say, it's
well,
flexible at the moment.
I think £10,000 was put forward by the opposition. I think other countries, you know, if we looked through Europe, we'd find there are other countries with thresholds. Okay,
well, thank you. Another question which came through was, which has also placed your strengths, I think, on the tax side. I mean, in August, the HMRC actually sent out a circular, I think, saying 300 banks were ordered to hand over details of their customers with offshore accounts in order to, well, we assume to shine a light on possible tax evasion. So the questions come in. Should a bank submit possibly a SAR on each UK person or entity who holds an overseas account but cannot provide a good reason for it?
Well, yeah, I mean, it's a much broader question, actually, which is that it doesn't have to be a bank on revenue. I mean, if you're a professional and you're served with a PACE order, you make the assumption, as you must, that that order couldn't have been obtained without reasonable grounds for suspicion having been established to the satisfaction of a judge, otherwise the order wouldn't have been served. So it actually is a problem that arises across the board, and there are differing views on it. Some people do take the view that they should report immediately, and particularly where and it says slightly tongue-in-cheek, but the truth is, I mean, one does see this, you get asked about this. Very often this type of case that comes in, where there is some vulnerability on the part of the institution. And they think, oh gosh, should we have reported this earlier? Because they then start looking at their file and they realise that, well, just, you know, maybe with the benefit of hindsight, there were one or two little odd things about this. And should they row for the shore immediately? And I think the answer is probably yes. I mean, you know, you want to be on the side of the angels if you're if you're in that situation. But of course, you've got to also think about your client. I mean, the bottom line on it is that you approach each case on its own facts if there are reasonable grounds, and those reasonable grounds can be supplied by information that's come into your possession, that's been given to you by a public authority. Then follow the language of the legislation. And if that requires you to make a report, the fact that it takes the authorities no further whatsoever is none to the point. You don't want to take chances.
Mm-hmm. Okay, well, that's clear as far as it goes, as you say, case by case. Well, that probably follows on another question which was following on from that, and it was covered a little bit from a slightly different angle. The context where a man is divorcing his wife, maybe this is very close to home from the questioner, who knows, but he's saying he's transferring money offshore in an attempt to keep it secret from the spouse, the wife in this instance, who's being divorced. Would this count as a legitimate attempt to move funds out of the jurisdiction, given, this is the question, given that it may frustrate a potential court order, so it's all hedged with potentiality, of course, but would that be, in your sort of view, grounds to submit a SAR, do you think?
I think it's grounds to make sure you don't commit the criminal offence of conspiring to pervert the course of justice. I'd be much more concerned about that.
Right.
I think at this point, I mean, because that's the alleged criminality. I mean, you just don't want to do these sorts of things, and certainly, lawyers and bankers don't want to get involved. It's almost a case of again, the client's telling you too much. It reminds me of the time when the money laundering regime first came into play in the Channel Islands, and I was instructed by one of our noble institutions that is represented out there. And they said to me, one of the things they wanted to advise on was what was the meaning of suspicions. They were terribly concerned that they'd have to report. Their attitude was, we've got to report everybody, which actually was terribly unfair, because if you look at the Edwards report on the Channel Islands, there's 101 reasons why you might legitimately move and still move money to the Channel Islands. So in a sense, it was a silly thing. But the follow-up was, if we do have to report, is it an offence for us to advise our customers to go and move all their money to I think it was Cayman or Panama at the time, one of the jurisdictions that was unaffected. And I remember just thinking, well, hold on a minute. It may not actually be strictly a criminal offence, the moving of the money, but you don't want to wander into conspiracy to pervert territory.
Yes.
So be careful.
Yes, there's an added dimension to all this with the latest US sort of action in regard
that's
to
another
Switzerland,
matter.
I suppose. So it's
Yes.
upping the ante, as they say all the time. Well, thank you for that. And moving on to actually a sort of much broader issue, on the back of your comments about the House of Lords report, I read the report and I noted that it said, as of July, so it's slightly out of date now, that there were 7 EU member states who had not fully transposed the directive, which was due to be implemented, I think, on the 15th of December, if my memory serves correct, 2 years ago, or 2007. Yesterday, I received a transcription of an ECJ decision, which was rapidly translated by the law firm. Thank you very much to them. That Spain was in breach, and the decision had gone twice through the ECJ, the correct process, and saying they hadn't got their act together. And the only fine at the end of the day was to pay court costs. So it's really the question being, if there's not really any sanction for even putting in place the directive into domestic law in these countries, do you think there's any hope for a sort of level playing field and implementation?
I mean, that's why I made that caustic comment about a supposed level playing field. I mean, look, it's right. The sanction ultimately is, of course, enforcement proceedings the Commission could take, and it's been threatening, I think, in 2 or 3 cases, that it would ultimately do that. I mean, we do have there are so many different issues with Europe. Of course, we've got this broad, the expanded Europe that's with us now, and we know that some of those states, I mean, they do have histories in terms of the operation of organised crime. So even though they may be compliant, I think the message has got to go out that people still got to be very careful with certain of the new European accession states, because Spain is an old one.
Thank you very, very much indeed. That was a fantastic exposition, and to you too for listening and for participating.